All right, so I'm gonna get started. Annie and I are gonna be platooning tonight. I'm gonna go first, she's gonna go second. We're gonna kind of go back and forth because we're both lawyers. We work for this firm called Fisher Phillips. We're here in San Francisco. We're also in Sacramento. We're small. We're a very small little entrepreneurial type office here in San Francisco. There's maybe 6 lawyers. And this is the first time we've done something like this. So we wanted to come out and try to talk to you about what we do, and we think it's a subject that a lot of you might find a lot of interest in. Now, one thing I do is wage and hour work. And we have about 50 minutes to an hour to talk, and we have a lot of material to get through. But I think it's a good thing to start with because, number one, it's super boring. Okay? Wage and hour work is really boring, and somebody has to do it. But most people glaze over, so I'm going to try to get through it, and then we're going to get to some of the more interesting things like transgender laws, retaliation lawsuits, things like that. Okay, those are more interesting, but let's get through this. All right. Who here knows about President Obama's federal exemption increase at the federal level, which for the first time in a very long time is going to make the minimum wage for a salaried exempt employee in California actually lower here than it is at the federal level. Are you aware of this? Yeah, it's pretty interesting. Everyone in California always assumes that we're the most liberal state and we always have the craziest labor laws. Well, this law actually makes your exemption even higher than California. All right, there was a very aggressive thing done at the federal level. So this is the kind of stuff that we're always looking at. And December 1, 2016, this is going into effect. So, if you have employees, watch out, especially in the tech industry when you're operating on some of those exemptions. Watch out for how much salary you're paying because of those federal rules, they're going to change. And by the way, I don't expect you to read all of these slides. It's all going to be available to you. We're happy to email it to you afterwards. We have some materials as well. What I'd prefer you do is just pay attention and try and soak up some of these bigger issues. All right. What do you do when you have a wage and hour issue? It's an audit question, right? You just want to look at what you're doing, who you're paying, what you're paying, and see if you have to reclassify. And that's just that can be if you have 1 employee, it could be whether you have 10. We find it particularly important if you've had employees for a while and you haven't looked at what you're paying them. But we often find that your people will usually come to you and tell you what the problem is. So it's not something you have to watch out for. California's minimum wage also went up. Again, went up this year. It's going to continue to go up. So that's most of you probably know that. Again, this is pretty dry stuff. We are lucky that we live in a place that is really unlike anywhere else in the country. And the reason is, we all have these local cities that like to pass their own laws about how the minimum wage is going to be. All right, if you lived in a place like, Arkansas, you'd have 1 law. You know what the minimum wage is, and that's it. But here in California, Berkeley, Emeryville, Mountain View, Palo Alto, all these places have their own laws. And all of them have different rules about how much you have to pay somebody if they're working there. All right. So here's what we're looking at, and this is all pretty cutting edge stuff because we don't even know, for example, what Richmond or Palo Alto are going to do. We just believe it's very likely we're going to see an increase in 2017. You should just be watching out for that. Does anybody know what the Private Attorney General Act is? Anybody here? All right. It's an act in California that's kind of crazy where your employees get deputized by the state of California to be wage and hour cops and then write you tickets, right? They can actually sue you for the type of tickets that the state of California would sue you for. And it only exists in the labor realm. And it usually exists in the realm of misclassification. When you have somebody who's an independent contractor, you bring them on just to do a job, and then they say, no, I'm not an independent contractor. I'm your employee. I'm suing you. So that's what that is. If you ever see that, if you ever see PAGA, Private Attorney General Act, please give me a call because it's a big deal. And it happens to just about every business. It really does. All right, Equal Pay Act. Everybody down with this? Equal Pay Act. It's really, really cutting edge thing here in California about gender equality in pay. We deal with this, pretty much all the time. We don't really know what's going to happen, but what's interesting about the Equal Pay Act is how it's going to be impacted by these new transgender laws that are coming down. And we're going to talk about that in a little bit. But basically, you really just can't have unjustified wage differentials. If you have a female worker or a male worker, they're doing the same job, you really should be paying them the same amount of money. It doesn't matter what their background is, it doesn't matter what their resume says. California is very liberal when it comes to that, and here in the Bay Area in particular, we're going to see a lot of prosecution on the Equal Pay Act. So it's just something to keep in mind. This is a very equal state when it comes to wages. All right, 2016. What is this? What is today? October 20th? Okay, so 3 days ago, the EEOC issued their guidelines about who they're going to target. Who's the EEOC going to target for their prosecutions in 2017? The gig economy, right? They're going to target the gig economy. They're also going to specifically target algorithmic-based hiring processes. All right, that's us, everyone. That's us. Who uses algorithmic-based hiring processes? Silicon Valley does, right? So the EEOC is really going to be looking at why you hire people, what process you go through to hire people, who you select. And if you're using these types of things, temporary workers, various equations and things like that, the EEOC is specifically targeting that. They just released that as their mission. All right, so it's just something to watch out for. And this is an interesting one. It's taboo, right, to talk about with your coworkers how much money you make. There's new laws against that. These are laws that are challenging the very foundation, the very fundamental concept of what it is to be in the workplace. This taboo, no, I can't ask you how much I make. I can't ask my boss how much my coworker makes. These laws are now saying it's discrimination. It's illegal to have that kind of taboo environment. And I don't think a lot of people know that these are things that are happening. All right. Arbitration, does anyone ever here have arbitration provisions that they ever deal with? Yeah, they're under siege right now. Okay, we've got this case that just came down in the Ninth Circuit. And by the way, that's the highest court in the land right now because the Supreme Court pretty much doesn't work at the moment. So the Ninth Circuit basically is saying that arbitration agreements don't fly. They don't work because they think it violates what's called the National Labor Relations Act. We don't know what's going to happen with this law, but if you have arbitration agreements, don't think they're just going to protect you from a lawsuit right now. Right? This area is in flux. And now I know I'm going through this all very quickly, but again, you will have about 30 minutes to ask questions at the end. I tend to get a lot of questions about class actions and arbitration, and it's like 90% of what I do. But if you do have questions, please let me know at the end. All right. What's next for them? You can read all that. I'll just tell you what it says. We have no idea. Okay. At some point, the Supreme Court's going to have to revisit this, but with 8 members, we don't really know. All right. So with that, I'm going to turn it over to Annie for local stuff.
All right, everybody. Because we're in California and California law isn't enough in itself, like Jason mentioned before, we have local rules for whatever city you might have employees in. So what we're going to talk about first is paid sick leave law. I'm kind of just going to run through a very overview-ish and just give you a very general idea about California, and then we'll touch upon the little areas of San Francisco. Does anybody have employees outside of San Francisco? You do? Okay. Well, we have some charts in here. If you have specific questions, you can let us know later on. Okay, so paid sick leave law. Basically, under California, you have to provide your employees 1 hour of sick leave for every 30 hours worked. Does that make sense? Okay, so if you're an exempt employee, which means you're not an hourly employee, you are, you're salaried, be careful with that. Jason didn't talk about this, but under wage and hour issues, make sure you're classifying your employees correctly, that they're supposed to be exempt, they're not an hourly employee, and that gets really tricky also. So assuming if you are an exempt, properly categorized employee, the assumption is you're working 40 hours a week. Unless for some reason your regular schedule is under 40 hours a week, and for startups that's probably not the case, because you guys are probably working well over 40 hours a week. So you earn 1 hour of sick pay for every 30 hours you work as an hourly employee, and you accrue that over the course of the year. So basically this applies to everybody, whether you're a part-time employee, temporary employee, or full-time employee. So this applies to everybody if you're working in San Francisco and California and anywhere else basically in California. There are some exclusions. I don't think anybody in here is subject to a collective bargaining agreement or you're an airline employee or anything like that, so we're not going to touch upon that. Okay, so who is covered? Basically everybody. You guys can read through that yourselves. If you work 2 hours in the city, anywhere, whether it's in San Francisco, Oakland, Emeryville, you're going to be covered under this. You're going to need to provide sick leave for your employees. Now, a lot of you guys might have, well, let me ask you this way. Who has a separate sick leave policy and a separate vacation policy? Does anybody have that? Who has an all-encompassing PTO policy, pay time off policy, where it's kind of all under one umbrella? Okay, so that's where it gets a little bit tricky. For vacation slash PTO, you have any unused and accrued and unused time. I just said that wrong. Any accrued and unused time. If you separate from the company, you have to pay that out if it's vacation or PTO. For accrued and unused sick time, you do not need to pay that out. But if it's all under one umbrella as a PTO policy, it counts as vacation and you have to pay it out. So that's kind of confusing. If you guys have questions, let us know afterwards. Okay, so how much paid sick? You guys can look at this a little bit later. So there's something called an accrual cap, which means you can accrue up to a certain number of hours in a year. There's also called a use cap, which means you can only use up to a certain number in a year. So that's kind of how the chart breaks down depending on where you are. And a lot of cities also has a distinction between whether you are a large company or a small company. In San Francisco, I believe it's less than 10 employees, you are considered a small employer. So if you have 10 or more employees, you're considered a large employer in San Francisco. Same thing for Oakland. In Emeryville, they're very interesting. If you have, I believe it's 55 or less employees within Emeryville, then you are considered a small employer. So make sure you have your numbers correct depending on where you work. And if you've got employees working in different places at different times, you might have to prorate it. What we usually suggest to our clients is basically wherever you have employees, take the most generous law, whether it's San Francisco, whether it's somewhere else, make it the most generous law, otherwise you're gonna have a hard time tracking sick leave for the different cities that you have employees in. Okay, front loading. What does front loading mean? Front loading means you give all the paid sick leave up front. So you have your employees start on January 1st. Here is your 3 days worth of sick leave up front. Some places allow it, most places allow it. Places that don't quote unquote allow it, they just don't address it. So for the most part, front loading is available. And if you front load it, that means your cap is actually different. So we can talk about that also if you have questions afterwards, and I'll let you inspect that graph on your own. Again, these materials are available. We're gonna send additional stuff to Rob that he will send out to all of you guys. So you will have this material. When can employees begin using paid sick leave? Almost everywhere, you start accruing, you start building the time, you start earning the time immediately when you start working, but you can't use it until the 90th day of employment. So the only exception is San Francisco right now. But that is about to change because San Francisco law is being amended to be more in line with California law. So that'll be more in line starting January 1st, 2017. Okay, permissible use is basically anything to do with medical leave. You can use it. If you question it, and your employee says you're discriminating against them because you're trying to scrutinize what their medical leave is, you're going to have a problem. So, I mean, California is going to interpret what sick leave use is for pretty generously. Let you read that on your own. Same thing. It's very insignificant, the differences between the different cities. Some of the recent changes is that victims of domestic violence, that's included under the permissible uses for sick leave also now. Okay, so lots of different stuff. There are questions that we get, like can we require medical certification from the employees just proving that they're sick? That's kind of a dangerous question. The only time I would say yes, you can do that is if it's really clear that they're abusing it. Let's say they ask for vacation for the exact same days that they're asking for paid sick leave and you told them no. That might be a reason where you're saying, it's a little suspicious there, I might need you to provide me a medical notice. Or maybe it's, I need sick leave the day before Christmas and the day after. That might be a little bit, suspicious also. So, that might be, some of the questions that come up. Retaliation, that's going to be another issue that Jason gets into later on. If an employee, says you're retaliating against them because hey, I took sick leave and now you're retaliating against me. That's protected action under this law, so you want to be careful of that. As far as notice provisions, you're supposed to provide how much the employee has available as far as sick leave on their pay stub or something in addition to their pay stub when you provide that to them. So that's one of the notice requirements. So lots of stuff under paid sick leave. I'm going to pass this back to Jason.
You got applause. I didn't get any applause. All right, so a lot of this stuff's pretty detailed, right? A lot of this stuff might not apply to you at all. This might just be an interesting learning experience. But I think something to keep in mind is that as you grow, if you get bigger, you do have to bring on employees. This is a playbook that you really should have before you do that, all right? Because if you're trying to scramble when you don't really know, somebody like the DLSC is going to find you first. All right. And now, who the DLSC? The DLSC is an agency that employees go to when they think they have a problem. Okay, basically, when there's been a wage and hour problem, they said you haven't paid me, or you breached a contract, you took away my stock, or whatever, they're going to go to the DLSC and they're going to file a complaint. They don't need a lawyer to do that, and it's super, super employee friendly. Independent contractor is going to go there when they say that they're your employee and that they're not your contractor. That's just so you know, that's who they are. I'm going to tell you a little war story about them later. Now the EEOC, that's a federal agency. The EEOC is another agency that we deal with all the time. And basically this is retaliation. And so if somebody says you fired me, you shouldn't have fired me, you let me go, you had a layoff, why'd you pick me and not him? The EEOC is the one that's going to get involved. All right? If you ever get an EEOC complaint, you really got to hire a lawyer. Because they're basically cops, all right? So if you get it, anybody here work for the EEOC? Okay, good. So basically, they act like police, and they operate under the police subpoena power. So if the EEOC comes knocking on your door, you should probably talk to a lawyer. It's just the right thing to do. All right, now I'm going to roll right into this issue, which I think is really interesting, all right? Because this is really cutting edge stuff, and I maybe will expect some questions on this. Transgender laws in the state of California and the country as a whole. But here, they're pretty much as advanced as they get. You're at the cutting edge of this issue, and it's really a really interesting social issue as well. What happens when you have an employee that switches genders? Okay, it's what happens when you have a coworker or a partner or another founder that switches genders. All right, I'm going to tell you a little story, maybe a little bit later if I have time, about one of my cases right now where a couple of founders of a company got together and one of them switched genders. And that person was the face of the company, and they didn't necessarily think that was the right face of this particular company. It was a really difficult issue, and we worked through it. But what does the law say, and what doesn't it say about transgender issues? Basically, these new laws in California are saying that the three big things, discrimination, harassment, retaliation, they all apply to transgender issues. And where does that come into play? Dress codes, bathroom use, hiring and firing decisions. This is where it comes into play. And basically, you can't prohibit anymore in California grooming or dress codes to stop a transgender employee from identifying as they want to identify. You can't even ask them to disclose whether they're transgender. You can't do that in California, and you certainly can't reject a candidate who said one thing and then expressed another. So it's just a really interesting and new issue, and there's quite a lot of slides on this because we try to be very detailed at Fisher Phillips on this topic because there's just so much to it. And people that are really invested in this, you can imagine, are very invested in this topic. It's very important to me. Right? So we have a lot of materials on this, but I don't know how many of us are as knowledgeable about this issue as the California legislature appears to be about, for example, using the proper gender name or pronoun to refer to somebody in the workplace. I would say generally, if you don't know, just ask the person and it's going to be okay. But it's as detailed as requiring a court order if somebody wants to change their gender. It's just these rules that go on and on and on. But the one I think that really catches people is the restroom question, right? Which restroom would somebody use? And basically, the law is that you must allow somebody to use a restroom that is basically corresponding to either their gender identity or their gender expression. What does that mean? I like to usually take questions at this point, but we'll take them at the end. Basically, you can't force a person to say, I want you to use that bathroom because of your sex. You can say, no, you identify as this gender, so you can use that. So that's the way the law is here in California, and it's pretty unique. Now, you can have a unisex bathroom to be available, but you can't force them to use it. You cannot do that. And if you have an objection because of a gender-conforming employee, you can't say that they're right. Okay? And that's where we really get into it. What if one of your employees or one of your clients or somebody who's in your office says, I object to this person being in the bathroom? You have to say, well, they have a right to be in there. Okay? And it's a law that is going to take some time to get used to, but that's just the way it goes. Right? Religious beliefs, transgender is going to trump in California. Right? So if somebody says I have a religious objection to that person sharing my bathroom with me, the law here says, thank you for telling me. I'm not going to discriminate against you for telling me that, but they have a right to be in that bathroom. Okay? It's just funny that the bathroom is where this plays out. It just is. In the arena of the law and transgender in the workplace, the bathroom is the battleground. And it's just, I think it's just a sensitive place where we tend to feel vulnerable, I guess. But it's really no different than imposing religious beliefs in any other way. Okay? But this is probably the most controversial thing we're going to talk about tonight. So if you do have questions about it, happy to address them later. What's your best practices in your particular workplace for dealing with the transgender issue? Basically, you want to have just good policies when it comes to harassment, discrimination generally, because the enforcement mechanisms are the same. And you definitely, if you're going to do sexual harassment training, I don't know how many of you have gone through sexual harassment training? Okay. Check on your vendor who's doing that to make sure that they're training on transgender issues, because it's going to be mandatory very soon, and you might as well start doing it now. All right. Some of the other things you can do is basically just ask them, like I said. Just ask your employees, what they prefer, and make sure that you're reporting everything, payroll, health plan, when they make that change. It just shows that you're being a proactive manager. All right, and that's about it. I covered all this stuff. These are all just best practices for dealing with these laws. But at the end of the day, the one thing I want to say about it is that we don't know the answer. All right, any lawyer that comes up to you and says, I know how you can be compliant with the transgender laws, nah, they don't. They have some best practices. They think they know. They don't, because these are new laws and they're going to change. And it's just good that we're starting that conversation. All right, coming up, Annie.
Okay, so a lot of the gig economy these days have delivery drivers and warehouse workers and a lot of things. So what happens when you have an employee that injures themselves? So what we're going to talk about a little bit is if you have the law overlays with workers' comp. Have you guys heard of Family Medical Leave? California Family Rights Act? Okay. FMLA, CFRO for short. And also disability law. So a lot of that overlaps with each other when you have an employee injure themselves. So we're just going to run through that really quickly. If an employee is injured for a work-related reason, it's going to be covered under workers' comp law, and you're going to need to pay for their medical care and all of that good stuff. You can't put a limit on their leave, and if disability benefits by workers' comp, then they don't receive it under the state. So we'll just run through that a little bit. So the main thing to think about under workers' comp, if your employee is injured, you cannot retaliate against them. You cannot fire them because they've been injured. You cannot replace them because they've been injured. Sure, you might need to put someone in there temporarily, but you cannot permanently replace them. So that's kind of the gist of this whole thing. The last sentence in there, disability discrimination law applies too. So have you guys heard of the Fair Employment and Housing Act, FEHA? Basically, that's the California version of Title VII. Whether it's based on race, religion, gender, or disability. So that's one of the items that fall under VHUB. Okay, so FMLA and CFRA. Under these laws, an employee who has a medical-related reason can take up to 12 weeks off. They can be eligible if they've worked at least a year, 1,250 hours in the last 12 months, and you have at least 50 employees in a 75-mile radius. You guys might not fall under that category yet, so hopefully you don't need to worry about that. But eventually, if your companies have grown large enough, then you'll absolutely fall under FMLA and CFRA. Even if you don't fall under FMLA and CFRA, we'll jump past that. We need to talk about ADA or FEHA, where you have to go through the interactive process. I'm kind of jumping through this a little bit. So ADA and state law. So does anybody have employees where they've had to deal with the interactive process? Do you guys know what that is? Basically, you can't just fire an employee because he says, hey, I can't come to work for X number of weeks because I have some type of injury or some type of medical condition where I can't work. You have to go through that back and forth process with them, where they say, here are my limitations. And you say, here's your job description. Please take it to your doctor and have your doctor tell us what of these job functions you can and cannot complete. And if there's a restriction, let's say there's a lot of lifting or a lot of bending and walking, maybe what percent of the time can you do that? How much weight can you lift? How far can you walk? So this is a conversation that needs to go back and forth. If the doctor comes back and says, hey, he can't work at all, you just need to not let him do anything for the next 2 months. Well, you can say, well, let's kind of have this conversation. What can you do? Maybe we can, let him work from home. Maybe we can, do something. So, and I would highly recommend that you get this interactive process in writing, because if that employee comes back and sues, you can say, hey, we did everything possible to get this employee back to work, and exhaust your resources as much as possible. So to prove an undue hardship is very, very difficult. For you to say, no, I absolutely cannot accommodate this employee because, we just have too much going on, we can't do it. To prove that is very, very difficult. Even though it might very much be true, to prove it is difficult. You're not required to provide an indefinite leave. If the doctor says, hey, this employee can't come back, we have no idea when this employee can come back. You're not required to provide that indefinite leave. You also can't have a policy where it says, if you have a leave for X number of months, or once your FMLA CFRA leave expires and you can't come back, you're fired. You will get in trouble for that. You cannot have a hard line like that. So a lot of it is about the interactive process. And I hate to put it this way, but it's kind of the process of just giving them enough rope. So, make sure, put yourself in the best defensible position possible. So that's kind of what we just talked about. You have to attempt to accommodate the restrictions if it's possible. And you can't have a 100% heal policy. You can't say, hey, you need to be 100% better before we allow you back to work. So, insurance. Anybody here provide insurance for your employees yet? Okay. So if you're under a workers' comp leave under FMLA CFRA, you do need to still provide them their insurance during this time. But if for some reason, most employers pay a portion of the premium, and the employee has to pay a portion of their premium. If for some reason the employee is unable to pay their premium, then there are some options available. You have to give them proper notice. Because they're not paying their portion of the premium, you have to discontinue it. There are notice requirements for that. Or some other type of arrangement can be made where you say, hey, we'll pay for it for X number of weeks, and when you come back, we'll make an arrangement where you pay that back to us because we're paying your portion of the premium. Under the ACA, otherwise known as Obamacare, they might have some other requirements that I am not knowledgeable enough to talk about, but we have benefits experts that can talk to you guys about that if you need. So, okay, if we replace the employee on leave with a temp who we like better, can we keep the temp instead? As tempting it as that is, no. They will say you are retaliating against them, they will say you are discriminating against them, so the answer is no. And again, same thing with the undue hardship. I'm going to jump to the next slide. So let's say, your company is not doing too great and you have to lay off a bunch of workers. Can you lay off the employee who's been out for 3 months and has been out on workers' comp? You probably want to, unless you are laying off the entire department, maybe that employee is in, that might give you an excuse to let go of that employee. Otherwise, having a layoff or reduction in workforce is not a good reason to give you an excuse to get rid of that employee who's been out on leave. So be very careful of that. So these laws, there's a lot of interplay between them. Workers' comp, FMLA, CFRA, and discrimination under the American Disabilities Act and FEHA. So don't consider any of these laws in a silo by itself. They interact and you want to be very careful. And this is one of the most common questions that we get when an employee gets sick, goes out on medical leave, has a family member that's sick. So these are things that come up in people's lives. So it comes up pretty often. Okay, retaliation. Hand off again.
Thanks. All right, so that's the last handoff. So we're moving into retaliation. Who here knows what I mean when I say retaliation? Yeah. Who here is afraid to raise their hand? It's the #1 filed employment lawsuit in the country, by far. As a lawyer, I can tell you it's the hardest to defend. It's the hardest to prosecute. It's just the hardest to deal with. When I think of labor and employment law and the risks that face the smallest employer to the largest one, a startup with 2 founders that are just trying to get it off the ground, to Google or Apple. Retaliation is going to be the same problem for everybody. And what is it? What is it? It's every single thing we've been talking about tonight. Okay? If it's a transgender issue, what is the end result of a problem? It's a retaliation case. And if it's an ADA issue, if it's an ACA issue, if it's a workers' comp issue, what are you going to get in trouble for as an employer? Retaliation. Even if it's your partner and things go south and you have a divorce with your partner, and I don't mean this in like a marital way, I mean this in a business way. Because very often when you have a small startup and the founders break up, it's more like a divorce than a business breakup. Retaliation is something you have to be very, very concerned with. All right? So we end with it because chances are every single person in this room at some point in your career is going to be dealing with a retaliation case. All right? It might not be you. It might not be somebody that claims that you retaliated against them, but you're going to know somebody that was a part of one, or you're going to work for somebody that was a part of one, and this is going to come up and they're going to shudder. So, although most of you here have probably never dealt with it, this is a good thing to absorb. It's a really good thing just to be here and listening about, because it's an important area. Not just in California. This is an important area across the country. All right. And if you remember something from tonight, remember this. What is retaliation? It's an examination of behavior after the allegation. Okay. It's not an examination of what you did wrong. It's not discrimination. It's not an examination of that you didn't hire somebody properly, or that you fired somebody improperly, or that you didn't pay somebody enough money. That's not what retaliation is. Retaliation is judging you based on what you do when they tell you you did it. When somebody comes up to you and says, you discriminate against me on the basis of my race, and you feel very insulted because you are not a racist, well, what do you do in that circumstance? How will you be judged in a retaliation case? It's how you respond to that allegation that will determine whether you retaliated or not. All right? And that's very important, because you could have done everything right up until that moment. And it's in that moment that most people screw up. And that's why we see so many retaliation claims. All right? So that's why it's really important to be aware of this issue and really to know what it is. All right? And what is it? Protected activity. Okay? So protected activity can be so many different things, but basically it's somebody walking up to you as a manager and saying, I think you're breaking this law. That's about it. You could be doing everything right. They could be so full of it. But they came up to you and they said, you're breaking this law. You're doing this wrong. You violated this, you violated that, so on and so forth. They don't have to say they're suing you. They don't have to say anything like that. They can just accuse you of doing something wrong. At that moment, the retaliation flag should go right up. Because at that moment, you're going to be judged by people like me, by lawyers who are going to examine your behavior after the allegation. Okay? And the adverse action is what you do next. So what do? All of you, you're all entrepreneurs, you're all ambitious, you're all going to manage people someday, if you don't manage them right now. You're all going to be put in positions of supervisory authority. And what are you going to do when that happens? Well, you're going to do something. You're going to do something. And is that going to be considered an adverse action? And are they going to be able to make a connection between what you did and what they said? That's retaliation. And as you can tell, it's pretty easy to make that connection. And now here's a little example for you. And this is based on the Equal Pay Act, where a worker basically finds out that a male coworker makes more than she does. And she goes up to you as the manager, or me as the lawyer for the manager, and she says, he makes more than me. I found that out. I think I should get a raise to be paid as much as he does. Well, you don't have the budget to do that. What do you do? What do you do? What you do is going to determine whether or not there's retaliation. And the question that you need to ask yourself is, on this one, did she just engage in protected activity? Or what about this one where she actually cites the Equal Pay Act and says, no, I'm doing this under the Equal Pay Act. It really doesn't make a difference. If somebody's coming up to you and they believe that they've been wronged, and you're the manager, how you respond to that is going to determine the future of that lawsuit. And trust me, that is more important than whether or not you are actually paying them less on purpose. It really is. It really is, because you could pretty much prove very easily that you're not a discriminating manager. But it's really hard to prove that you didn't retaliate when somebody accused you of that. All right? So that's just important. And that's why we say opposition to perceived discrimination. So, for example, if you have a coworker come up to you and doesn't say, I'm being discriminated against, but that person is, it's no different. Right? It's really no different. It's the same thing. You can't punish them for that. But here's one silver lining to that. Okay, and especially for small employers. Okay, small employers, it's really important. It does not give somebody license to malinger, as we say. It doesn't give them license to just not do their job. They can't just say, aha, I put on the cape of retaliation. You can't retaliate against me, I'm going to go to the movies. It doesn't work that way. All right? They still have to do their job. And that's a weapon for you. That's something that you now know if you didn't know before. All right? That you got to be careful about retaliation, but you also know that I think people in California sometimes can be afraid of lawsuits. So when somebody complains about something, they climb up, they put on their armor. No, they can't just do nothing. All right? They still have to do their job. All right? What's the EEOC or lawyers like me? What are we going to look for? We're going to look for suspicious timing. We're going to look for times that you did it to one person and not to another. And of course, falsity for the reasons. The other thing, witness statements and stuff, that sounds really sexy. Like, oh, I'm going to take a witness statement, I'm going to go depose somebody, I'm going to sick my lawyers after you with meet and confer letters and cease and desist letters. That's sexy, it sounds great. But really, this stuff, these normal workplace things, are way, way, way more important. Right? They really are. And one of the things that we talk about in this presentation is avoiding pitfalls. Right? And one of the ways to kind of keep this all in your mind and to avoid these pitfalls is to understand where pitfalls are actually physical things you can fall into. So what are they? Number one, layoffs and RIFs. All right? Who here has been involved in a layoff or a reduction in force? Right? It happens all the time in this industry. That is where the retaliation can really come up, because you got to pick some people and you're not going to pick others. And the people that you pick, they're going to wonder why you picked them and not the other person. And they're one of the biggest areas where there's going to be retaliation suits. Same with in termination for poor performance. It's just, it happens, it's going to happen, but you really need to look at it and say, before I terminate somebody, have I given this some thought? Has there been even any evidence that I'm retaliating against them for anything that they did? All right. Doesn't mean that they don't have to do their job. Okay, if they don't do their job, you can terminate them for poor performance. That's what I said before. But you just at least need to be thinking that. I can't tell you how many times clients come to me, and I think I was talking to somebody before the event about this. It's like, unfortunately, people come to lawyers after these things have already happened, right? Well, with this type of stuff, you know where you need to be paying attention, right? And things like use of non-objective criteria, stuff like you don't fit our culture. We decided that you don't fit our culture. That's non-objective criteria. That's the kind of thing that a plaintiff's lawyer is going to drool over. Suing somebody for not fitting a culture could very much lead to retaliation. And of course, the bottom two. When you have a very flat organization, like an organization that has like 2 people, it's pretty hard to have a hierarchy. Okay, it's pretty hard to have separation of your HR manager from your controller, from your COO, from your EVP. So because of that, your decision-making process is probably going to include almost everybody at your startup, especially when you're smaller. Even larger startups tend to have pretty flat structure. That doesn't really work with the traditional writing of retaliation laws, because any decision by anyone who's interested in the outcome of the issue, every one of you is interested in the outcome of these types of decisions at your companies. So how can you separate yourself from the process? You can't. And that's why retaliation for startups is particularly dangerous, and why we spend more time on it than we ordinarily would in a presentation like this, because you can't get away from it. So you're already a target because you had to make a decision about termination or not hiring or a salary decision, and you were involved somehow in the underlying issue. You're just going to be, all right? There's no way to get around it. So it's something you need to be aware of, and it's something that definitely, I promise you, is going to happen to just about everybody here. Either you might be the one that gets retaliated against. I mean, you might be on the other side of it, but it's going to happen. And that's why I say all of these things are going to happen to you, every one of them. All right, and at least it's the kind of thing where have this checklist, and if you're going through one of these things or you spot one of these things, just ask the question. Okay, because if you're doing a little bit of investigation, if you're asking the right questions, you can get through it. And what are the kind of things you want to avoid? This. All right, these are the kind of things that the EEOC, in cases I've worked on, specifically when they see this kind of stuff, they're like, aha, retaliation, I got it. There's evidence of this. These people do this for a living. And you see any of that kind of stuff, especially the last one, big egos, and the EEOC is involved, and you've got a big ego that made a snap decision on an employment issue, it's just a crucible for risk. All right? So that's the adverse action. We talked about that. It's fine. This is how to do it. We can talk about that later if you have any questions about adverse action. I just want to go through. We're coming close to the end. So I do want to say, though, that if somebody is really screwing up, if you got somebody who's just not doing their work, if you're small, we've all been there, your partner's just playing too many video games or just not doing their job, don't sugarcoat it, all right? Be truthful, all right? Because if you sugarcoat it, if you dance around the issue, if the real reason for what you did is not what you said was the reason you did, that's going to be evidence of retaliation, all right? So, don't say it's an RIF if it's not. Don't say it's downsizing if it's not. Don't say you're firing somebody because you don't have the money if you have the money and you just want to hire somebody better. These things all come out in the wash. All right. So, one little practical piece of advice from us lawyers is just to say, don't say anything you wouldn't testify to in court. Don't write an email that you don't want a judge looking at. All right. I actually heard a congressman say that recently in a local election out in North Carolina. It's in North Carolina, Virginia, and I was like, that guy knows what he's talking about. He was a Republican, but he knew what he was talking about because he said, don't say anything you wouldn't testify to in court, and don't write an email you don't want a judge to read. I totally agree with both of those statements. All right. So we only have we have about 5 or 10 minutes left. And the way Annie and I were going to do this was to kind of go back and forth on this, on these sort of real world examples. So this might be a little weird walking back and forth, but you can take it.
I'll just stay here and talk.
Yeah.
Okay, so we decided to do kind of some scenarios from cases we've actually handled. And this is one I am currently handling, actually, where we have a startup. Is this working? Can you guys hear me? Okay.
Yeah, I'm going to have to be a ventriloquist, though, on the video, so.
That's okay. It's recording my voice. You don't need to have me on video. Okay, so basically, like a lot of startups, like a lot of tech companies, you have an unlimited vacation policy. So because they had that, basically they were like, well, take whatever time you need off. They had an employee who needed surgery and said, hey, I need X number of weeks off for the surgery. Sure, no problem, take it off. Never asked for any type of doctor's note or any type of anything like that. So the employee takes the surgery, comes back, works for a couple weeks, and then is fired. What does this employee automatically say? Hey, you terminated me because I took protected leave, or because you discriminated against me because I had a quote-unquote disability. Remember what we talked about before? All of those laws overlap. So I have this case on my hands right now where the employer tells me, hey, we terminated this guy because he was a bad performer, because we got all these complaints about him because he just wasn't doing the job. Do you think we had any write-ups? Nope, no write-ups. Do you think we had any evidence that this guy had been counseled? No. So what we do have on record is that this guy sent an email saying, hey, I'm going to be out for surgery for a while and I'll be back. And a few weeks later, he was terminated. So it makes it very hard to defend when you don't lay the groundwork. One of the things we always tell our clients to do is document, document, document. Sometimes employers want to be nice. They just say, hey, maybe you want to do a little bit better in this area. I don't have record of that. I don't have anything in email form or an actual form that says write-up or something that says you are not doing your job well. So when it comes to the time where you actually have to terminate an employee and you have nothing to show for it, that's going to be difficult. And even if you have an unlimited vacation policy, you still need to follow your steps. This employee, he hadn't worked for a full year yet, so he technically wasn't qualified for FMLA, CFRA, or any of those things. But there also wasn't, he's also alleging disability discrimination and that he was disabled. We have no idea what this alleged disability was because this interactive process that we talked about before never took place. So, but it's hard to prove that when you don't have these processes and procedures in place. So just kind of keep that in mind. So loosey-goosey is good for a while until a problem like this hits, and then you don't have any documentation to defend yourself. So that's just kind of one example.
All right, very good. I love how it's an unlimited vacation policy question. It went into a we're lawyers, write everything down story, which is true. That's what we say. This one, I'll be quick about this. All right, I've gotten this. This is a real life story that I get probably every quarter or so. I get a call. Oh my God, I got a DLSC complaint, but I thought I could handle it by myself. So I just, I didn't need a lawyer for that. So I just went down to the DLSC and I did it myself. And things went south and I lost. I need you now. That's a big problem. That's a big problem. Why? Because these administrative forums, they've got these things called statutes of limitations, and they've got these things called time to appeal and things like that. And lawyers, we're kind of slow. We're really slow. And by the time you come to a lawyer, it's probably too late. All right, and this happens all the time where somebody gets a bad decision with the DLSE and they totally didn't think it could happen to them, and all of a sudden they've got a judgment against them for $35,000 for this guy, half of this person's salary, and they don't know what to do. It's a tough situation. So the lesson to be learned there is that if you do get notice from the DLSE, or particularly the EEOC, and I really want to stress that, because you all maybe could handle DLSE on your own, maybe. But the EEOC, definitely not. But if you get one of these agencies coming after you, just get any lawyer. Just call a lawyer. Just call a lawyer and say, help me. I don't want to pay you, just help me. And that's the right thing to do. Go ahead.
Okay, everyone's an exempt employee. We don't need to track hours. So we're in the tech industry. It's really easy for us to say, let's just pay everybody a fixed salary and not worry about it and not track anybody's hours. So what happens is if you are misclassifying someone who should be an hourly employee and you misclassify them as an exempt employee and just pay them, I don't know, $50,000 a year or something like that, you could be in big trouble, because what's going to happen is this employee, assuming that the employee has been misclassified, comes back and says, hey, you categorized me in the wrong category, and I worked all these overtime hours. I worked from home when you didn't even know about it, and now you didn't pay me appropriate minimum wage. You haven't paid me all these overtime hours, and you owe me a ton of money. And because you terminated me, now you owe me waiting time penalties too. That's going to add up to a ton of money. Same thing for independent contractors too. If you guys are using independent contractors to do key work for your company, that's a very dangerous area also. So if you have no way to track your hours because you think everybody's a salaried employee, you're going to have a harsh reality check when they come back and say, look at my duties. I'm just really a clerical worker, but you've given me this manager title, but treat me like a secretary, and I should be an hourly employee, and you didn't pay me properly. So that's an example of misclassifying your employee as an exempt employee or maybe an independent contractor even. So be careful about what your employees' duties are and how you're classifying them. The question was, can I explain what an exempt employee is? So generally, there's two categories of employees. You have a non-exempt employee, which is more commonly referred to as an hourly employee. So an hourly employee is typically a non-management type employee who doesn't really get to make decisions as far as what direction their job goes in. This is how you do your job, and you just follow a certain procedure. Let's say a cashier. All I do is, ring customers up and check them out, versus a manager who might manage employees, who has the discretion to write up employees and fire them, has, determines their own, time schedule even. So that's a very, very broad description of what an exempt employee and what a non-exempt employee might be. Other exempt employees might be, executive level employees, or, there's very specialized employees. Jason and I are attorneys. We're considered a specialized type of employee who are considered exempt employees. So there's different categories of what an exempt employee is. But if basically you're kind of an employee that just follows a procedure that's in place, and there's really, no going off the tracks of doing their job, then it might be likely that they should be a non-exempt employee, an hourly employee.
So Annie, I don't mean to jump in, but in just a minute, we're going to invite you up to the microphone to ask questions.
And we'll be around afterwards also if you guys want to talk in detail.
And it's great if you ask questions into the microphone, just because then you get to be on our video and you get to be part of this process. So in just a minute, we're going to invite you to do that. I just want to tell one more story because it happens a lot. And as you grow and you start dealing with your founder stock and things like that, it's going to come up. And this is basically a situation where I don't need a written contract. The founders, we're tight. We know each other. We've gone to college together. We got a written agreement about stock, so we're fine there. But I don't need any other written agreements. Very dangerous. Okay, it led to a lawsuit. It was a very nasty lawsuit. Like I said, it was like a founder's divorce. I hate to say it, it's the same reason people get prenuptial agreements these days. But really, really, really consider, even at the very founding starting level of your company, if you have partners, just have a hard conversation, sit down, put some things in writing. It doesn't even matter if it's like reviewed by a lawyer. Just get some things down on paper, the rules of the road. Just your stock agreement is not going to be good enough. In fact, if you don't have agreements that cover other things, your stock agreement might be in jeopardy. Because unwritten terms of the other things are going to affect your stock. And you might not even know that. So from a contractual perspective, the real story here is just make sure that some of those key things are in place. All right, so at this point, we've gone through so much material. I just want to, there's a couple of more things we can go through, some real world examples, but we're about out of time. So if you wouldn't mind, Rob?
Up to the mic. It's going to go a long way towards us creating a great learning resource with our video. So come on down.
Annie, why don't you come back up here too, and we can both answer.
So I have a question. This is really terrific, by the way. Thank you guys very much. The use of interns, unpaid interns, is common in the startup setting. Can you talk a little bit about the perils and pitfalls of that arrangement and what companies should do to kind of, handle that sector properly?
Sure. Do you want to try, or do you want me to go?
Sure. The main issue, if let's say the EEOC or the DFEH or the DOL, when they look at this, is
those are all agencies.
sorry, using a lot of acronyms here. Those are all government agencies. If a government agency or if one of your interns files a lawsuit and says, "Hey, I'm improperly classified," the main thing that's looked at is the work that they're doing for the benefit of the intern or for the benefit of the employer. So if they're doing something that substantively contributes to what the company is doing, then it's going to be arguable that it's for the benefit of the employer more than the intern. But if it's more of a learning experience for the intern, then you can make the argument that it's more for the benefit of the intern, and it's justifiable that they're either not being paid a minimum wage or they're getting a stipend or credit or something like that.
Yeah. And the classic example there, right, is it's like you have an intern come in, maybe he's from a college or from a trade school, or maybe none of those things. If the reason the intern's there is because you really want to train that intern up in the industry or train them to do what you're doing, you're in decent shape. But the more times you send them to get you coffee, you're not in such good shape, because it's pretty hard to argue that that's for the intern's benefit, unless you own a coffee shop. Thank you so much for the question.
Thank you. Anybody else?
You again.
Hello.
Hi. So if you pay intern in this case, then you're fine?
If you're paying them at least minimum wage and for
Then-
all of their hours worked,
Okay.
you should be fine for the most part.
Okay. So how about independent contractors? What can they do? What can they not do? What is the best way to manage it? Because a lot of times, kind of that line between what you ask them to do and what employee does is not very clear. So how do you make sure that you don't step over that line if you hire independent contractors?
How many factors are in that test?
A lot, and there are different tests too. There's the IRS test, there's an EEOC test, there's court-made tests. You want to start?
Sure, yeah. There's a lot of, the answer to your question is complicated, because there's a lot of factors.
It depends.
Yeah. Well, boy, I don't like that lawyer answer. It depends. I'm too young of a lawyer to use that answer. But the fact is, there's so many factors to consider. I think what you want to look at is really the core, most important factor, which is the control test. And really what that means is, are you telling that independent contractor what to do? Okay. For example, right now I'm renovating my bathroom. I bring a contractor in to put the tile in. Do you know how many times I've told that contractor that he's doing the tile wrong? 0 times, because I'm a labor lawyer and I know not to do that. Because the more I tell him what to do, the more he's going to say, what do I look like, your employee? Right? So the fact is, independent contractors are given their own dominion and control over what they do. And the way that works is, if you have a business, a startup, and you need somebody to actually come in and do something like write your code or write your business model or do something that's really important for your business, it's going to be really hard to say they're an independent contractor. But if you have them come in to paint your office, that's not really part of what you do. You're not a painting company. So that's the control test. And that's kind of the big thing. So if you were going to really focus on one thing and not get into like the crazy long the crazy long list, that's your most important. But as Annie would tell you, that's number one out of
15 maybe.
a lot stuff. So yeah, there's a lot to it.
So because there's so many rules and regulations, and we're startups, very small, how do we know and how to navigate that order? What's the best way to deal with that if you're trying to hire your first employee or first few employees?
Go for it.
It's hard. I mean, you can Google a lot of these things, independent contractors versus employees, and it'll give you a list of things that you need to keep an eye out for. What Jason talked about, control, are you telling them what hours to work? Are you giving them specific instructions on how to complete their task? Like the difference between if I have another associate and I'm telling them, hey, you need to address these issues in this memo that I want you to write, versus me hiring someone to fix my roof. I might say to the roof guy, hey, come between the hours of 10 to 5, but I'm not going to say, this is how you need to put the shingles on the roof. Does that kind of make sense as far as what the two differences are? Are you providing them equipment, or are they bringing their own equipment? Are they able to decide their own profitability, or are you somehow controlling that? I mean, this is a huge issue these days. I mean, Uber is just the biggest example out there right now.
Anybody here work for Uber?
Are their drivers independent contractors or employees? There are so many lawsuits going on against Uber and Lyft and all those companies out there right now. It's a hot topic.
That's true. Nobody works for Uber because they're all independent contractors. So
Right. So,
That's a trick question.
You've got both sides of the issue there. All Uber drivers provide their own car. But Uber determines all the rates. They determine when the surge pricing is. There's just a lot of things that go back and forth. But the argument is the drivers get to determine what time they want to work. They can determine their own profitability if they want to find the surge times, or if they want to work at, morning or nighttime where there might be more customers. So there's arguments to both sides of that, and that's why those cases are so difficult. But Google what the factors are and try to meet as many of them as you can. So it's hard. Because especially if the government's coming after you, what they're looking for is taxes. Because if you're categorizing them as independent contractors, they're not getting taxes from you. So that's incentive for them to come after you.
yeah, well,
Thank you.
of course.
Anybody else?
Oh, thank you, sir.
One more question. So in very small companies, startups like 2, 3, 4 employees, finances are not stable, and they're not yet at the stage where like a layoff, a formal process occurs. But let's say fundraising doesn't work. They don't quite have the money to pay a salary that they might have agreed to pay. What room do companies have to be flexible? What documentation should be put in place? Suppose an employee agrees to say, well, I'll keep working if you can pay me in the future. What kinds of, can you speak to that? Because that's also not uncommon for very small companies.
Yeah, I'll speak to that. So there are some laws that give you reprieve if you're very small. So not every law that we spoke about today applies if you're under say 5 employees. But most of them still do. The onus on being a small business is hard. It's no doubt about it, whether you're a startup or otherwise. So really, I think the best thing that you can do when you have a situation like where you just can't fund an employee and you got to let them go, or you have to just, if they offer to say, I'll work for free, I'll work for stock, you have options. You don't have to just shut them down and say, no, you can't work for free, I can't do. No, you have options. You'd want everything in writing. You want to do as much as you can to come to a contract. There's a lot of different forms of compensation you can do. There's ways you can create partnerships. There's ways you can do different corporate formations. You have a lot of different options at the very small level. And the truth of the matter is, and this is a practical thing I've learned, I've been a lawyer for about 9 years, and a practical thing I've learned over the years, people sue, right? Some like government agency isn't just going to sue you for no reason. Somebody has to sue you. And I find the reason why the startup industry is so interesting is because people are pretty congenial with each other, and they network, they do events like this to get to know each other. If you have a good relationship with all of your people, and they're the type of people that are willing to say, I will work for free because I believe in this company, those are not the people that are going to sue you. Those are not the people that are going to go to the government. And I've polled some of my clients when I'm like, did you know that person would sue you before they did? Yeah, I knew. Or, are you afraid that this person's going to sue you? Yeah, they're the type of person that would do that. It's just funny, as a business owner, you get that feel. As a lawyer, we certainly get that feel. So I think that's my practical piece of advice, beyond all of these factors and scary things. Try to get a feel for whether somebody you think is going to sue you, because they're the ones that are going to do it. Oh, yes.
Is there any way through an employment application or a series of questions that you can get a feel for someone that's going to sue you?
Good question. I know what I want to say, but do you want to try to field this one?
I would not recommend asking if you've sued any of your employers in the past 10 years. That is a difficult question.
Yeah, so the question really is, how do you screen? How do you screen a potential litigant, right? How do you...
Through the indirectly asking them, through a series of many different questions.
Yeah, how would you screen to potentially find a potential litigant? Obviously not directly, couldn't do that, but how would you do it indirectly?
I think maybe questions about how they've gone above and beyond their duties, or how they've dealt with difficult situations, maybe where they haven't been attributed credit, or have they taken on a situation perhaps where they feel like they haven't been treated fairly. That might give you an idea of maybe how they think. Is there a victim mentality there? Is there maybe a mentality where they take ownership and fix the situation versus saying, oh, poor me, now I'm going to go sue? I don't know. That's just kind of talking off the cuff.
Well, here's what I think. I've done enough retaliation, discrimination cases, and one of the questions that lawyers always ask the plaintiffs is, have you ever sued anybody before? See, we get to ask that question, all right? Once it's a lawsuit, we get to ask that question. And man, people get really cagey about answering that question because they have relationships with all their former employers, or they have good or bad ones. And I think the way that that works out in terms of your question, check their references. Look at their resume. See if there's gaps. Those gaps might be because there was a lawsuit there and they don't want them on their resume. Check their references because maybe one of those references is this. The person worked here for 2 years. They worked here as an analyst. They made this much money. That's the end. We're not at liberty to say anything else. If you hear that, chances are there was a lawsuit and some lawyer wrote a neutral reference.
Well, just to buffer that also, we instruct all of our clients to provide that kind of information. Whether they're good or bad employees, you should only provide dates of employment and last rate of pay. So I wouldn't say write them off just because of that.
I would say it's a signal that if somebody has put that reference on their resume and that's what you get, that's maybe something you should consider. And but by the way, checking references is really important because if you check a reference and it's a bad one, that doesn't happen very often. But if you check a reference and it turns out to be a bad one, you should probably just move on to the next candidate at that point. I really do think that. All right, so.
Okay, come on, any more questions? They're not billing.
No, we're not billing.
Yeah. So
By the way, this isn't formal attorney advice, but really the purpose of being here is to help you absorb a lot of this stuff, be aware of some of these things. Don't take what we say at face value or gospel. Lawyers, in like many ways, we're like politicians. we have a lot of different views on these things. You might talk to another labor and employment lawyer and they'll tell you something totally different. Not that the laws are different, but that their interpretation is. This is just kind of our view and our firm's view, but please don't take this to your current employment lawsuit and say, Jason and Annie said that you had a bad reference, so I'm not hiring you. It's just food for thought.
All right, one more time. We've got time for some questions. Going once, twice. Let's hear for our speakers. Well, ladies and gentlemen, stay in your seats. We've come to the point of the event that you've all been waiting for. It's full. So, if you've stuck around this late, you will be handsomely rewarded, many of you. Has everyone entered the raffle who wants to enter? All right.
Oh, we've got one more card over here.
Going once, twice, hurry.
It's pretty good odds. Pretty good odds.
Okay. So I'll be assisted by my speakers. Hang on to this. So actually, I'm going to start off with some good stuff. It's the classic idea of the IPO jacket.
Nice.
Yes, it is very nice, and it's almost rainy season. The winner is, Jason, do the honors.
Jenny Shao, communications
Jenny.
consultants.
Come on down. Excellent. There you go.
All right.
Okay. How about unlimited pass to Idea IPO proprietary events for December 2016? So we've got a busy calendar in December. November's a little bit slow. So the winner is
Dr. Gwen Zhang.
come on down. There you go. See you at the next event. Keenan from Parisoma has a prize. Let the audience have a prize. Yes.
Okay, so check. Parasoma, who's familiar with what Parasoma is? Raise your hand. Okay, what is Parasoma?
Co-working space
Yes.
for the startups, and you keep doing events for them so that they get better opportunities.
Exactly. So we're a co-working space. We host a bunch of startups, mainly tech, or freelancers and entrepreneurs here to have a place to work out of so that they don't have to work at home. And we have a bunch of open air. Usually there's a ping pong tables we use. We have about 8 of them over here, lined up with about 6 chairs for collaboration in the community. We believe in, collaboration and being able to mingle and talk to each other as well as work very hard. We also have dedicated desks up there for people who just want to have their own desks assigned to them to come every single day. Or we also have private offices on the 2nd and 3rd floor. So from Parasoma, from our director, Todd Embley, he's not here right now, he gave out, with Rob, a 1-month free membership for the open space for you to use. This includes everything that an open space member would pay and would receive. So that's Wi-Fi, free coffee, free drinks, free events, as well as being able to meet all of these startups. Check. And the winner is... Sorry. Chandra Taneja from Tech... Wow, from Tech One.
Are you glad you put that in?
Congratulations.
All right, now we're on to the good stuff. That stuff was good anyway, but we have more good stuff. So we have a $50 gift card from Amazon, sponsored by Fisher Phillips. The winner is...
All right. Victor Nelson.
Victor, are you here? Going? No, it doesn't work that way. Must be present to win. So sorry,
All right.
Victor. You snooze, you lose.
All right,
Next.
let's choose again.
Yes. That serves him right.
Misha Yang.
Come on down. Here's your $50 gift card from Amazon.
Congratulations.
Congratulations. Okay, now we've come to the grand prize. I know you are all waiting with bated breath. Hurry up. Is that fair? Let's take a vote. Is that fair? All right.
She's like, I don't want any of the other gifts.
Well, anyway,
Strategic timing.
Well played. Well played.
so here is the grand prize. It's $100 cash, and it's real. I just got it from the bank this afternoon.
I'll hold it for you.
The winner is...
Go right ahead. You pick.
Okay. I'll pick.
Yeah, I'll hold it.
I don't want to be totally objective. And the winner is... Thank you, sir. Rohan Clark.
All right.
Pose for the camera.
Pose for the camera.
All right. Well, thanks everybody for coming.
Congratulations.
Congrats.
Our speakers will stick around, answer questions one-on-one, and take some food home.
All right.
See you next time.
Thanks, everyone.